Okay, so I want you to consider whether or not the plan you have, or you have a plan, and if the plan is directed by the documents you have, and if the people who you're naming in those documents are aware of what your expectations are. Now, there are some other issues that can come up. One is protection from estate taxes. Now, Washington State has an estate tax on assets above $2 million. Okay, and the federal government has an estate tax on assets above $5 million. So my experience is if you have an estate tax problem, you don't have a Medicaid problem. Okay, but you have a problem, and that's a problem for a different seminar. And I could certainly address those problems in my office. You can come and see me about those problems. And there are some things you can do to reduce or eliminate estate taxes. But folks who have liquid assets above $1 million with, let's say the home is paid for, and then they have some regular pension and Social Security income, maybe you put all that income together, and they have income in excess of $140,000 or $150,000 a year. You know, you could be in a worst case scenario where you're paying $100,000 to $120,000 to a nursing home and still have $40,000 or $50,000 of income for the well spouse. And even if the well spouse needed some money from the principal, you're not going to erode the principal significantly. So that kind of a situation is sustainable without moving money around to qualify for Medicaid. And people who have $1 million invested, they don't want to take it all out from whatever those investments are and then try to buy a huge annuity like that. And so they are, I think, consider themselves self-insured, and it probably makes sense at that amount. Another issue is subsequent marriages. So let's say a couple get married later in life, and they each have been living independently on their own and doing fine. And so their expectation is, well, we're going to live together happily, and then when one of us dies, the assets I've accumulated will go to my kids from a previous marriage. And the other spouse has the same idea because each of us were able to live alone on the income we had before. But in their mind, they're not thinking about, well, what about if I get sick? So if anybody comes and asking me about prenuptial agreement or those kinds of issues, I always talk about long-term care insurance because that you have to have that covered. Because if you don't have it covered, DSH is going to consider his, hers, and ours as all being available to pay for long-term care costs. They don't care if there's a prenuptial agreement or anything. If you have it and the spouse has it, or you have it as community, it's all available to pay for care costs. So the well spouse is certainly going to shelter their assets, right? And so then it behooves the person then who was thinking my assets are going to go to my kids, but now I'm sick. So what option do I have? I guess I have the option of transferring this money or this asset that I thought was going to go to my kids. I can either now spend it on my care, or I can give it to my spouse. So that's really the options. The option of giving it to my kids isn't there because if I give it to my kids, I'm not eligible for Medicaid. So what usually happens in that situation is I say, well, let's have a family meeting and let's explain to the kids how the system works. And the kids can have some input as to whether it's fine to give it to the step-parent or whether they say, I'd rather see it go to DSHS than to that person you married. So I've actually never seen it that bad, and I've been in a few of those meetings, and they actually go pretty well. But it's good to talk about that and how that works. And so those assets can hopefully be protected.